the victim's sister, remembering it in a way that helps her point of view, because again, in these materials that the defense attorney presented to me, it was alleged that not only was this woman victim involved in drugs and prostitution, the sister was as well, and that a part of the reason that they concocted the story and put the blame on this Jeffrey Muldown fellow is they did not want their parents and relatives to know that they were doing these unsavory activities in Northeast Detroit. Again, a little bit too dramatic, a little bit on the not quite believable side, but certainly possible. I mean, as a prosecutor, as a police officer, you see things worse than that all the time. And so I said to the defense attorney, a way that we can kind of get the judge's attention on this is that why don't you file a motion requesting that this sister be asked to take a polygraph test. Now, polygraph tests are normally not admissible in court proceedings because there's a wide divergence of opinion as to how reliable they are. I happen to have gone from a mild supporter to a very strong supporter. I really believe in polygraph tests, and I'll get to that later on. But polygraph tests are admissible for, it's the one place where the rules get reasonable. Polygraph tests are admissible in post-judgment proceedings to try to bring out facts, to at least open up the door for a new trial or other proceedings. And so I said, why don't you ask the judge to do this? Now, knowing darn well that the judge has no power really to compel this witness to do anything, it was just a way to get the ball rolling again, to get in front of the judge, because the old judge who had denied even the evidentiary hearing had now retired, and there was a new judge on the bench. And this guy was kind of savvy, kind of a streetwise judge, was a good defense attorney, really bright, really smart, and we figured that he will see what we're doing. He will take this and run with it as a way to kind of call witnesses in, have the evidentiary hearing that the first judge denied, and maybe, just maybe, we'll get this person to take a polygraph, and if that person takes a polygraph, then others will take a polygraph. And by the way, by this time, Mr. Muldown had already taken a couple of polygraphs and passed them both, which is the other thing now on his side, which I forgot to mention. I keep on pointing out there were things that were blocking my passage on this side, but there was also good stuff lining up on his side. Well, the defense attorney does that, and we go into the judge's chambers, and it's October 6th, and we say, these are our plans, this is what we want to do. The judge says, hey, guys, all well and good, but I can't do anything because you, Mr. Defense Attorney, have already filed your pleadings for a petition for review in the Michigan Supreme Court. Because it's in the Supreme Court, I don't have jurisdiction of the case. Now, I'm not going to mention this judge's name because he still is a friend. The fact of the matter is he was dead wrong. When you file a petition with the Michigan Supreme Court, you're asking the Supreme Court to accept jurisdiction. While that petition is pending, the trial court still has all the jurisdiction it ever had. It could hear the case. But it seemed to both this defense attorney, John Royal, and myself, that what the judge was basically saying is that, look at your request for a polygraph examination, you know that I can't grant that's not going to fly. This is an old case. The judge did say, look, I read your submission, your affidavits, the explanation, the possible other defendants, the other possible reasons for the attack, the polygraph results, and I think that you have a high chance of success with the Michigan Supreme Court. So I'm not going to do anything. And so we walked out, and I said to John Royal, I said, well, actually, John said to me first, he said, what the hell are we going to do now? I said, I don't know, because I knew exactly what he meant. The trial judge had just turned down this chance for an evidentiary hearing. This was the second time it happened. The trial judge also said, have faith in the Michigan Supreme Court. They will read these pleadings, and they may very well reverse. The reality, and apologies to anybody in the audience who's an appellate judge or a Supreme Court justice, the reality is that when you've got a 10-year-old case nobody in the higher courts gives much attention to these petitions. That's a weakness endemic in the entire system. Barry Scheck writes about it in his book, Actual Innocence, and it's just a truism that when you have an old case, judges tend to think of all of these petitions asking for a new trial as just so much BS piled upon BS. Because, and let's be fair to them, most of the petitions that they get are exactly that. These guys are guilty. They are trying to find their way out of it by creating some new theory, by saying they have a new witness. There are witnesses who they say are recanting. They have like 1,001 reasons, and when you get into them, it's like the boy who cried wolf. I mean, after you read your, 3,475th petition, and you say, another thing with ultimately no substance, as these things come across your desk, you tend to think less and less of them. And I knew, and John Royal knew, that no matter how good the submission, our chances of getting the Supreme Court to really look at this were very, very small. And again, it was still going to be my position that if they did look at this, that I was going to say, as long as you give us an evidentiary hearing, that's all I'm really interested in from a due process point of view. I'm a prosecutor. I'm supposed to present the state side. I will do that. For God's sakes, let the defense at least have a shot. Let them come in and present their evidence, and then have somebody in the black robe that gets paid the big bucks. Let that person decide, and I'll be happy with that. But I knew that as I walked out of that conference with this judge on October 6th, that this guy's chances were practically nil, which meant this, that I had a guy that was serving the 60 to 90 years. In my mind, he was probably guilty, but I was no longer absolutely certain he was guilty. I also figured that if there were a new trial, that whether or not he was actually guilty, the fact of the matter is the chief corroborating evidence that we had wasn't going to be in there. And so if a new trial were held, there's a good chance that the jury on the available good evidence would find him not guilty. So how could I in good conscience let this continue? And so I told the defense attorney, I said, look, I don't know what I'm going to do because the rules leave us in limbo. The Supreme Court has this petition. I don't know if they're going to do anything. They probably won't do anything, but I promise I'll do something. Well, I kind of dragged my feet for a couple of months, and then finally, at the end of December of 2001, I wrote, and again, this went through a couple of drafts because I was trying to figure out procedurally what to do. I wrote a motion to the Michigan Supreme Court in which I just basically laid out all of these complicated, ambivalent, bivalent factors that he could be guilty. There is evidence in support of that. On balance, I thought that the good evidence that remained after you excised out the bite mark evidence was still strong enough. On the other hand, the defense had raised some serious issues. Again, I figured, look, I'm just a lawyer, I'm just a prosecutor. I'm just going to tell the Michigan Supreme Court honestly what I think that we have, and I'm going to let them make the call. I'm not going to ask for a new trial, but I'm going to certainly suggest that the matters raised in the defense petition certainly deserve to be looked at. And that if they are true, it could constitute what we call a good cause under the Michigan court rule to grant a new trial if you justices thought it were true. But I, as a prosecutor, am not taking a position really one way or the other because I'm not sure it's good cause. But if this is true, it is good cause. All right. That goes to the Michigan Supreme Court. And in May of 2002, they come down with a decision that says, because of the problems with bite mark evidence, we are going to grant a new trial. And they even then